Next, I would like to cover California workers' compensation. Workers' compensation is the nation's oldest social insurance program. It was adopted in most states, including California, during the second decade of the 20th century. The workers' compensation system is based on a trade-off between employers and employees. Employees are entitled to receive prompt, effective medical treatment for on-the-job injuries or illnesses, no matter who is at fault, and in return are prevented from suing employers over those injuries. As a result, California employers are required by law to have workers' compensation insurance, even if they only have one employee. And if your employee gets hurt or sick because of work, you are required to pay for workers' compensation benefits. Workers' comp insurance provides basic benefits, including medical care, temporary disability benefits, permanent disability benefits, supplemental job displacement benefits, and return to work supplement and death benefits. The vast majority of workers' compensation claims are resolved without any problems. However, sometimes a disagreement can arise between you and your employee over issues such as whether the injury was sustained on the job or how much in benefits they are actually entitled to receive. When a dispute like this arises, the Division of Workers' Compensation can help resolve it through its Information and Assistance Unit or by going before a judge at one of the division's 22 local district offices, plus their satellite offices that are located throughout California. Please be advised that if you are a dealer and you don't have any employees, you are still required to carry workers' compensation insurance, just as a sole member LLC even. If you're an out-of-state employer, you may need workers' compensation coverage if you have any employees regularly working in California or if you enter into a contract of employment here. First, I want to cover medical treatment. Doctors in California's workers' compensation system are required to provide what is called evidence-based medical treatment. That means they must choose treatments scientifically proven to cure or relieve work-related injuries and illnesses. Those treatments are laid out in a set of guidelines that provide details on which treatments are effective for certain injuries, as well as how often the treatment should be given, the frequency, the extent of the treatment, so that's called the intensity, and for how long, which is the duration, among many other things. To comply with the evidence-based medical treatment requirement, the state of California has adopted a medical treatment utilization schedule. The medical treatment utilization schedule includes specific body regions, guidelines adopted from the American College of Occupational and Environmental Medicine's practice guidelines, plus guidelines for acupuncture, chronic pain, and therapy after surgery. So there's a lot of guidelines to abide by here. The Division of Workers' Compensation also has a committee that continuously evaluates new medical evidence about treatments and incorporates that evidence into its guidelines. Copies of the ACOEM guidelines are available for review at your local district workers' compensation office. Other guidelines not adopted can be reviewed and downloaded from the Division of Workers' Compensation website. If your claims administrator has established a network provider or a healthcare organization, your employees' work injuries and illnesses will be treated by a doctor in that network. So your insurance professional will definitely be able to guide you on this. These networks of doctors are similar to health maintenance organizations. If your employees qualified to pre-designate a personal physician and did so prior to being injured, they can go to their regular doctor for their workers' compensation care. Most workers fully recover from job injuries, but some continue to have medical problems. Permanent disability is any lasting disability your employee experiences which results in reduced earning capacity after maximum medical improvement is reached. If your employee's injury or illness results in permanent disability, they are entitled to permanent disability benefits. No increase in an injured worker's PD on account of a psychiatric injury is allowed unless the physical injury was catastrophic or the injured employee was a victim or a witness to a violent crime. Getting your employees back to work after an injury is one of the most important things you can do for their health and the health of your business. Workers who qualify and return to the job as soon as medically possible have the best outcomes. They recover from their injuries faster and suffer less wage loss. You, your employee, and your employee's doctor should communicate openly and frequently for the best results. You should implement an effective return to work program. And I'm going to show you how to do that. An effective return to work program, which leads to your employee coming back sooner, can result in employees' benefits in numerous ways. Such a program can help avoid millions of dollars in fines and penalties, reduce workers' compensation costs, retain experienced employees. It's going to improve employee morale and productivity, increase competitiveness of your business, and help ensure equal opportunity of employment for persons with disabilities. Employees participating in a return to work program can protect their jobs and income, avoid long-term unemployment, stay physically conditioned and mentally active, maintain daily structure and social connections provided by work, and participate in injury and illness programs in the workplace. When an employee has been hurt on the job, personally contact the employee, tell the employee that medical care will be provided while the claim is pending, and that other benefits may also be provided after the claim is accepted. Discuss the return to work process with your employee. Stay in contact with the employee. That's one of the best things you can do, and always be available to answer that employee's questions after they've been injured. Also, be mindful of the employee's situations and needs and show respect for the employee as a person. This will help allay the employee's concerns, avoid possible misunderstandings, and encourage the employee to have a positive view of the return to work process. Discuss with the employee the essential functions of his or her job. Essential functions are the fundamental purposes of a job. After you reach an agreement with the employee about the essential functions and duties of the employee's jobs, put this information in writing. If it is not obvious what kind of accommodation would be appropriate, you will need to obtain the employee's work capacities, which describe the tasks the employee can do safely. You also need to obtain the employee's work restrictions, which describes the tasks the employee is limited in doing and cannot do because of the injury. If you ask the employee to sign a medical release, limit its scope to the employee's work capacities and restrictions. Do not ask about the employee's medical condition, treatment plan, prognosis, or other matters that are absolutely unrelated to work. With the employee, explore ways to accommodate the employee's injury. The employee may already have useful ideas based on firsthand knowledge of the employee's job and a personal understanding of his or her injury and disability. Keeping the needs of both the employee and the employer in mind, consider the employee's work capacities and restrictions and all possible jobs available to the employee. Evaluate whether the employee can perform the essential functions of those jobs with or without a reasonable accommodation. Use outside resources if necessary. Share all important information, communicate openly, and encourage a genuine, meaningful dialogue with the employee. Assess how effective each accommodation for that employee would be in allowing the employee to perform the job. You may find it helpful to request feedback from the employee's primary treating physician or other healthcare professionals. So staying in contact with them is going to be imperative. You must consider accommodating the employee in the following order unless you and the employee agrees otherwise. So number one, you're going to have to provide accommodations that would enable the employee to stay in his or her original job, or reassign the employee to an equivalent vacant position in the job the employee is qualified to perform and perform reasonable accommodations as needed, or reassign the employee to a lower graded vacant position in the job the employee is qualified to perform and provide reasonable accommodations as needed, or finally, temporarily assign tasks that the employee is able to perform while recovering. I want to repeat that important statement. Provide accommodations that would enable the employee to stay in his or her original job, or reassign the employee to an equivalent vacant position in the job the employee is qualified to perform and provide reasonable accommodations as needed, or reassign the employee to a lower graded vacant position in a job the employee is qualified to perform and provide reasonable accommodations as needed, or finally, the last step would be temporarily assign tasks that the employee is able to perform while recovering. Make an offer based on the accommodation that you select, and this could be, but it's not necessarily an offer of regular, modified, or alternative work to reduce workers' compensation costs. After the employee accepts your offer, encourage and support his or her return to work. If the employee is still recovering from the injury, the primary treating physician or other healthcare professional should reduce or remove restrictions as the employee's condition improves. This will allow you to adjust accommodations accordingly to aid the recovery process. Continue to communicate as part of the ongoing interactive process to ensure that the accommodation is working as anticipated. So once again, I just want you to be aware, if you own a dealership in the state of California, even if you are the only employee, you are required to carry workers' compensation. This is the state law.